So, very good evening, my dear friends, and it is a great opportunity for all of us to once again learn, and for me also to revisit this particular subject of insolvency and bankruptcy laws. Actually, the nomenclature of the course is PG Diploma in Insolvency and Bankruptcy Laws. Actually, what is the difference between insolvency, bankruptcy, and liquidation? These are all the three things we are supposed to know. Today, the law is codified into one particular basket, but otherwise, the law had to be a little different for taking it as insolvency and bankruptcy. Earlier occasions, insolvency was referred to only individuals, and bankruptcy was referred to the firms, and liquidation was referred to corporates. Corporates means companies registered under the Companies Act. So whenever the institution has to be closed down, then you call it as individually it is insolvency. If it is firm's bankruptcy, if it is corporate entity, that will be taken as liquidation. So when this particular situation comes, now insolvency and bankruptcy has been clubbed together for the reason that this is called IBC, Insolvency and Bankruptcy Code 2016, that has been enacted. Prior to that, what was the situation and why this particular subject matter has been brought into force now? Prima facie, my dear friends, in the earlier occasions, a person's liabilities are more than assets. People used to think he is bankrupt, but it's not correct. A person means a person can be an individual, a corporate entity, a juristic person. If his liabilities are more than assets, people wrongly used to think it's a case of bankruptcy or insolvency. Absolutely wrong. Because every one of us will have more liabilities than assets, at least in the younger days. Like housing loan, educational loan, only after crossing 60, children are settled, all our loans will be cleared. Until then, always liabilities will be more than assets only. Except that the value of the property we purchase through bank loans will go up. What is the concept then? The concept is that a person is, if unable to pay his debts, then you have to adjudge him as insolvent. Not that because his liabilities are more than assets. This is the fundamental principle we have to understand. I may have capacity. I may purchase a Maruti car taking a loan from Bank of India, then a Renault from another bank, and I start paying installments. No difficulty. I might have taken housing loan also. I might have also taken educational loan also for my two children. Actually, this is what exactly happened. But as long as I am paying to all the institutions' financiers the repayment of loan installments regularly, nobody can say I am an insolvent. It's defamatory. If somebody says so, I can charge him under IPC for defamation, apart from taking compensation under civil law. So what happens here? This is a situation where a person's liabilities are more than assets. It does not lead to insolvency. If a person is unable to pay his debts, only then it will lead to insolvency. The same analogy applies to an individual, which is called insolvency in earlier time. The same analogy applies to a corporate entity, which is called liquidation. And the same analogy applies to a partnership firm, which in fact would be called bankruptcy. This is how the nomenclature differs. At this juncture, what we will have to understand is that for insolvency of individuals, partnership firms. Earlier, there used to be a legislation called the Provincial Insolvency Act or Presidency Towns Insolvency Act. In fact, I have done this in Bombay High Court for some time back. I got a very first-hand experience. Under the Presidency Towns Insolvency Act, Madras, Bombay, Calcutta and Delhi, the insolvency concept is totally different. Under the Provincial Insolvency Act, the concept is different, but the same legislation applies to individuals and firms alike. But if it is the case of a corporate entity, then the liquidation process differs because the liquidation process is identified under the provisions of the Companies Act. That was 2013. Earlier, it was 1956. We have got a company legislation originally brought into force in India in 1850, subsequently amended, and I think 1913 it was again reformulated, then 1956, then 2013. Now, the Companies Act is the crux of our discussion. Actually, in 2016, the government thought that we will abolish this Provincial Insolvency Act, we will abolish the Presidency Towns Insolvency Act, and we will make out a common code for all kinds of insolvencies with a differentiation in the divisions of this particular code. So the code has been divided into the first part with regard to the insolvency of corporates. It is termed as insolvency. And the other part termed as the insolvency of individuals. And the other part also is there, which is taken as insolvency of partnership firms, which is of course termed as bankruptcy. Actually, when a company, you come to the corporate entity running with 1,000 workmen, for some reason it could not pay the debts, it has to be wound up. Then what happens? About 1,000 families will be on the road. Our constitution is framed on this concept of social justice. So the government thought, if you kill a company, you are killing 1,000 families. 1,000 workmen are roosted, each family with average 5 members, 5,000 people will be foodless. So, instead of providing food, you are removing food. So the government thought, this is not correct. We had to evolve a social justice policy. For that reason, a sick industrial companies Special Provisions Act had been enacted earlier, where a company is found to be sick, don't wound up, you try to revive it. It is like a person is sick, you revive him, make him healthy, push him back in the society again. A car is defective, take it to the shed, repair it, put it back on the road. Company is not working well, take it to the Sick Industrial Company Special Provisions Act, go to BIFR, AIFR, in fact, recirculate the funds, make a consortium, repair it, make it with life and inject life, oxygen, and you find it can withstand, put it back in the market. Unfortunately, this legislation has become a big failure. This has become a big failure. In those days, there was an institution called Board for Industrial Infrastructure, BIFR, and Reconstruction, BIFR, then above that AIFR, and ultimately that did not work well. It has not given the yielded expected result. At the same time, the government mooted the idea that why can't we club the winding up process, the winding up of all the persons into one code, including companies. don't have a separate legislation for individuals, for corporate persons, for partnership firms. You have a common code for one and all, and you work out with a common philosophy and merge the Secondary Companies Special Provisions Act also. Then what will happen is the concept of revival, putting oxygen and life into a dying person, will be fruitful and it may yield good result. On this particular basis, the particular enactment has been brought into force, that is the IBC, that is Insolvency and Bankruptcy Code 2016. The Companies Act 2013 brought into force the National Company Law Tribunal as a special adjudicating authority for issues pertaining to company law matters. The IBC has removed the jurisdiction of civil courts and authorities and then has taken it to the corporates are concerned, NCLT has to adjudicate. If it is a case of individuals and firms, the DRT, Debt Recovery Tribunal, will have to entertain the jurisdiction. On this basis, a particular program has been made out and the scheming has been made under the Act where different fora came up for this particular purpose. Don't think here under IBC you are going to study only NCLT and corporate laws. You have got corporate laws also as your syllabus. So, some of the lectures I give to LL.M on corporate laws, I will put them to your WhatsApp also, group WhatsApp. You may take the benefit out of it for knowledge sake, because unless you have thorough knowledge about the corporate law, the Companies Act, you will not be able to understand the concept of NCLT. Then you will not be able to understand the powers of NCLT. Then you will not be able to understand the modus operandi of IBC. So, you have to definitely understand the background of Companies Act also, even though it's not my subject. I don't intrude into that particular arena. You have got one paper in that way, the introduction, authorities, and CIRP liquidation process. So, obviously, you must have a little knowledge over this particular aspect of company law also. So, what we now get into, earlier on insolvency of individuals and firms, it was the civil court which was having jurisdiction, and then the Presidency Towns Insolvency Act and Provincial Insolvency Act were enacted to deal with that particular subject matter. Subsequently, IBC has come, it has consolidated, and the individuals, firms, and then the particular corporates, everything is covered under this particular code. Then you may put a question to me, sir, if that is the case, there are societies, cooperative societies, what is the fate of that? Well, that is a different subject matter. Winding up of cooperative societies is covered under the Cooperative Societies Act only. Closing down of societies registered under the Societies Registration Act is covered under Societies Registration Act. There are separate legislations for that. In the same way, if the trusts are to be closed, the trust would be closed as per the trust deed. But a company has to be closed, you have to come to NCLT only. Whether the company has to be closed voluntarily, whether it has to be closed with the CIRP process, you have to necessarily come only under the IBC before the NCLT. Then, suppose there are occasions where the central government thinks a particular conduct of a company is detrimental to nation's interest. Then also, the Register of Companies at central government officers can move, that is MCA, Ministry of Corporate Affairs, can move an application before the NCLT. NCLT then can take action. So, there are different legislations for covering these things, but now for insolvency is concerned, it is the IBC which has come into vogue. This is the fundamental thing we have to understand. So now Provincial Insolvency Act, Presidency Towns Insolvency Act, both are not in existence. It is only the IBC which is in vogue, which has to be applied thereon. This is what you will have to understand. Then friends, apart from this, you have to keep abreast of the developments in the code, the latest case law also. There are about 8-9 most important judgments, which in fact sooner or later I will share with you, and that also you can take care of, and slowly you have to in fact get into the subject matter. In fact, earlier there used to be liquidators who are now to be licensed by the IBBI, that is the Insolvency and Bankruptcy Board of India. Unless you are licensed, you can't in fact enter into the scene either as a resolution professional or as a liquidator. You will not be allowed to deal with this particular subject matter. As a lawyer you can, as a representative of the company, a company secretary can do it. A chartered accountant, a cost accountant can do it, but others are not permitted. Unless a person is in fact qualified, passed the examination conducted by either Institute of Company Secretaries or IBBI, and then a qualified resolution professional, this particular in fact subject cannot be taken up. So in this particular time, the advantage of this course is that you will gear up yourself to face the examination. It is not that easy to face the examination. Then you are qualified, then you can appear, you can be enrolled, then you will be in fact appointed as one of the resolution professionals in routine. Of course, there is a procedure for that. It's too early to go into those details. Then you can know thereon. So now basically here the structure you have to understand. The insolvency issues are concerned where a person is unable to pay his debts, he would be adjudged as insolvent. For that, earlier there used to be two legislations, Presidency Towns Insolvency Act and the Provincial Insolvency Act, and those legislations have been repealed and a consolidated legislation has come to deal with individuals, the partnership firms, corporate entities under the Insolvency and Bankruptcy Code 2016. Apart from that, the Companies Act provisions also would be attracted with regard to the functioning of the NCLT. Here you have to understand the regulator, that means the authority to control, regulate, issue guidelines on insolvency matters in India is IBBI. That means Insolvency and Bankruptcy Board of India. The adjudicating authority on disputes is the National Company Law Tribunal, where above that there is an appellate body called NCLAT, National Company Law Appellate Tribunal, against which orders which one can go in appeal to the Supreme Court under appropriate appeal provisions. SLP need not be filed. There is a right of appeal provided in the Act to the Supreme Court also. So this is the hierarchy. Then for share markets, the regulator is SEBI. For dispute resolution, the dispute resolution body forum is Securities Appellate Tribunal. For company law matters, the regulator is MCA, Ministry of Corporate Affairs. For dispute resolution, it is the NCLT, the National Company Law Tribunal. In the same way, here the appellate body for that is NCLAT, and now the next part is the Competition Act, where earlier it is the MRTP Act which has been taken into Competition Act, and under the Competition Act the provisions are transferred to the NCLAT today. So there is no separate body, MRTP Commission is not there. Subsequently, Competition Tribunal is gone, Competition Commission is there, and against that the dispute resolution body is again NCLAT, National Company Law Appellate Tribunal. So for lawyers, this is a paradise now, because a lot of expansion has come, fora expanded, and a lot of bodies came, so that there could be lot of areas where one can appear, and then one can ultimately, in fact, make out a good practice also. So tomorrow, you students can apply to IBBI, write the qualifying examination. If you are qualified, you can become RPs, IRPs, that is interim resolution professionals or resolution professionals. That is the best advantage you get, in fact, once you pass that course. To pass that course, this course will give you the boost and the background, so that based on that, you can make out a very good study and then get the fruits out of it. So friends, with this brief background, we will start studying slowly the various issues as per your syllabus, which has been already put into the WhatsApp group. Your syllabus is CIRP, initiating an application for resolution, role of interim resolution professionals, committee of creditors, powers, duties, information memorandum, resolution plan, and methods. Actually, unless you understand the scheme of the code, you can't understand this subject matter. So, I will explain in my next session the scheme in general, what for it is enacted, and how many divisions are there, and what is our division. Then, in our division, what is CARP process? For that, there are certain technical terms. We will have to first understand the technical terms, like who is a creditor, who is a debtor, what is CIRP, what is RP, who is IRP. All these things we are supposed to understand. Probably like a story, I will have to tell you as to how the process starts in the court, and then in what it goes up, and then ultimately it will end up in a revival of a second institution, failing which it will end up in liquidation of that particular institution. So my dear friends, this is the subject matter for our discussion in this particular semester, which may run over 4 months with summer holidays also. Every Saturday, barring second Saturday, probably we will be meeting. And what I suggest is that we will be meeting regularly every Saturday, and the lectures on every Saturday I will put in YouTube also, so that you will get the double benefit, and any important material is there, that also I will put forth, so that you can take best advantage of that. So tell me, with that background, I think we will meet again next Saturday. Next Saturday is, in fact, prepare for minimum 1 hour, because we slowly going to the depth of the subject matter. It is an abstract subject. I will divide it into segments, and slowly I will introduce you. Probably after 4 or 5 weeks, you will understand definitely the entire structure and design of the legislation, and you will feel very interesting into the depth of the subject also. So there is no difficulty, and I wish you a very fruitful academic year and session. I wish you all the best. So thank you very much. Goodbye.